Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Juvenile assault/battery lawyer in Chicago. If you are a juvenile that has been accused of assaulting someone, creating reasonable fear of harm, or battering someone, contacting someone in an unwanted, harmful, or insulting way, you need legal defense services. At Combs Waterkotte, we have deep experience in Illinois criminal defense. Our legal team includes a former cop and prosecutors, and we can intervene immediately to challenge police reports and witness statements. To obtain a Chicago juvenile assault/battery lawyer in your corner, who will understand how your case is being built and who can challenge it effectively, call our Chicago criminal defense firm now at 3125-00-HELP or contact us online for a free consultation. Understanding juvenile assault versus battery in Illinois. Illinois covers assault and battery in Section 720, ILCS 5/12-1, and Section 720, ILCS 5/12-3. Assault definition and examples. Assault is engaging in conduct that places another in reasonable apprehension of receiving a battery. An example of this could be threatening physical harm or raising a fist in a menacing way. Battery definition and examples. Battery is knowingly without legal justification, causing bodily harm or making physical contact of an insulting or provoking nature. Examples of this would be punching, kicking, or slapping. If you are a juvenile in Illinois being investigated for assault/battery, it is imperative that you quickly retain legal defense services. Common types of assault and battery cases in Chicago. You can be arrested for assault/battery as a juvenile in Illinois if any of the following allegedly happened. Assault. You threatened physical harm. You raised a fist without contact. You attempted to hit someone. You made verbal threats and aggressive actions. Battery. You hit or punched someone. You pushed or shoved someone. You spit on someone. You threw objects at someone that made contact. For juveniles, these cases frequently occur at school, on the bus, on school grounds, or when a teacher's allegation escalates into a juvenile court case. In many situations, what begins as a school fight, misunderstanding, or heated argument can quickly turn into police involvement and formal juvenile charges. With these cases relying upon witness statements, school reports, and limited evidence, a Chicago juvenile assault/battery lawyer can help you challenge the evidence, identify inconsistencies, and build a defense that protects your rights and future. How juvenile assault cases are investigated in Chicago. Specialized units within the Chicago Police Department, CPD, investigate juvenile assault cases and focus on rehabilitation over punishment for minors under 18. Collaboration with a Children's Advocacy Center, the Youth Investigations Division, and Special Investigations Unit, SIU, may handle these cases, collaborating with a Children's Advocacy Center. Detention time is based upon age. Individuals under 12 can be held for 6 hours, whereas a 12 to 16-year-old can be held for 12 hours for nonviolent crimes or 24 hours for violent crimes. The investigation. From here, the investigation involves detectives conducting interviews, gathering video evidence, and a state attorney can review the case and file a formal juvenile petition in severe cases. Potential DCFS involvement. If the assault comes with allegations of abuse or neglect by a caretaker, the Department of Children and Family Services, DCFS, can begin an investigation. Burden of proof. The prosecution will still have to prove that you were delinquent beyond a reasonable doubt, but a jury trial is not usually held in these cases. What happens after a juvenile arrest in Chicago? If it is alleged that you committed assault/battery in Chicago, we can represent you through the juvenile justice system process. This may include station adjustment. Police may use a station adjustment to handle the case without court involvement. This may include curfews or community service. Detention hearing. The detention hearing must take place within 40 hours. Release or detention. You may be released to a parent or guardian or held in a juvenile detention center. A judge may also order home confinement, electronic monitoring, or community programs. Formal charges. The state's attorney decides whether to file a juvenile petition. Formal charges. The adjudication hearing. This is similar to a trial, where a judge will hear evidence to decide if you committed the offense. Disposition hearing. If you are found guilty, this is where the judge determines the outcome, which could include probation, counseling, or, in serious cases, placement in a secure facility. Adult prosecution. In more serious cases, a juvenile may be transferred to adult court. Can a juvenile be tried as an adult for assault or battery in Chicago? If you are 16 or older in Chicago and charged with a forcible felony, such as aggravated battery involving a firearm, you may be prosecuted in adult criminal court. Some cases require mandatory transfer to adult court, while others may be transferred at the prosecutor's discretion. In discretionary cases, which can apply to juveniles as young as 13, the prosecutor must request a hearing. A judge will then decide whether the case should proceed in adult court, based on factors such as the safety of the public, the seriousness of the offense, your criminal history. Once transferred to adult court, an assault/battery case cannot be returned to the juvenile system. Additionally, adult convictions for assault/battery come with much more severe penalties, including mandatory minimum prison sentences. To better understand if your case is at risk of being transferred to adult court, speak with a Chicago assault/battery lawyer today to review your situation and protect your rights. Penalties for juvenile assault/battery convictions in Chicago, Illinois. Penalties for a minor convicted of juvenile assault can include probation, can involve school attendance, counseling, or curfews, community service, therapy, restitution and fines, court-ordered payments to the victim or community, electronic monitoring/house arrest. Detention in IDJJ facility can be until the age of 21. Adult prosecution, transfer, where significantly harsher penalties can apply. Whether you are charged with assault or battery, the penalties in juvenile court depend upon the severity of the offense, your prior record, and the circumstances of the case. To protect your rights and fight for the best possible outcome. In your case, we encourage you to speak with one of our Chicago juvenile assault/battery lawyers immediately. Defenses to Chicago. Juvenile assault/battery charges. Common defenses in Chicago juvenile assault/battery cases include self-defense or defense of others, defense of property, false accusations, lack of intent or accidental conduct, alibi, misidentification, insufficient evidence, lack of credibility/inconsistent statements, mutual combat. By preserving evidence, such as photos, videos, or text messages, and consulting with our Chicago juvenile assault/battery lawyers, we can identify the strongest defenses available and build a strategy to protect your rights and your future. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.